happy to be opening this Humans in AI week at the AI Collective with those two brilliant minds that are joining here today in order to talk more about neurotechnologies and predictive technologies in the criminal space. For those who are joining us for the first time, my name is Anna, and I am the resident philosopher at the AI Collective. The AI Collective is a global nonprofit community founded in San Francisco. It brings together over 100,000 members worldwide, amongst innovators, policymakers, scholars, and builders committed to fostering trust, openness, human flourishing, and empowerment in the future of AI. And today we are continuing our new track of conversations called The Mind Under Control. And as you know, this is an online conversation series that we created together with the Center for Neurotechnology and Law, which is an international research hub based in London, looking at how neurotechnologies intersect with law, human rights. And if you are curious to explore their work, you can check it out on their website, neurotechlaw.com. And as part of Humans in AI Week at the AI Collective, we are very glad to host this event, this news session, exploring a question that may sound familiar to anyone who had watched Minority Report, the film. And the question is, what happens when technologies become capable of predicting human behavior before actions even occur? In other words, the concern is not that technology will suddenly allow us to read minds, but the concern is that increasingly sophisticated inferences about the mind begin to influence how rights, freedoms, and legal protections are distributed. And this raises difficult questions that our speakers will be dealing with today. For instance, can brain data ever become evidence? Should neuroinformation receive special legal protection? And how do we preserve the presumption of innocence in a world increasingly organized around prediction and risk management? And perhaps most fundamentally, even if future technologies become remarkably accurate, are there some things that democratic societies should refuse to know or refuse to use about the human mind? Those are all great questions, and we will try to explore them today. And to help us navigate that, we have with us two internationally recognized experts whose work sits at the intersection of criminal law, forensic justice, neuroscience, and human rights. And I would like to introduce them now. Apologies for summarizing the CVs because they were very brilliant and extensive, so I had to summarize a lot. But I will introduce our guest speakers this morning, starting with Dr. Alan McKay. So our first speaker is Dr. Alan McKay, co-director of the Sydney Institute of Criminology and academic fellow at the University of Sydney Law School. Dr. McKay is internationally recognized as one of the leading scholars working at the intersection of neurotechnology, criminal law, and human rights. He authored the landmark report, Neurotechnology, Law, and the Legal Profession, for the Law Society of England and Wales, one of the first comprehensive legal analysis of brain-computer interfaces and neurotechnologies for legal professionals. His work has helped shape international discussions on neurotechnology and fundamental rights, and he has written extensively on topics such as free will, criminal responsibility, human rights, and the regulation of emerging neurotechnologies. He currently serves on several expert bodies, including the Australian Human Rights Commission's Expert Reference Group on Human Rights and Neurotechnology. Thank you very much for being here with us today, Dr. Alan McKay.
Thank you.
And we also do have here with us Professor Purvi Pokahial. Professor Purvi Pokahial is a dean of the School of Law, Forensic Justice and Policy Studies and director of the National Institute of Criminology and Forensic Science at the National Forensic Sciences University in Delhi, India. with more than 25 years of experience in legal education and a distinguished career spanning criminal justice, forensic science, technology law, cybercrime, and artificial intelligence. She has worked extensively with law enforcement agencies, judicial institutions, and policy makers in India and internationally. She is the author and editor of several influential works on forensic justice and AI, and is currently editing a forthcoming Springer volume on neurotechnology and neurorights. Professor Purvi is also the former chairperson of the Indian Society of Criminology and one of the leading voices in the intersection of criminal justice, forensic science, and emerging technologies. Thank you very much for accepting our invitation, Dr. Purvi. And in order to extract the most of these brilliant minds, I will give them the floor for 20 minutes presentation each, and then we open to the Q&A, and I hope that you in the audience will be preparing your questions and comments to our speakers. I will also give opportunity for people on the audience to speak on the mic directly to our speakers, if that's the case. And I will be collecting some interesting comments on the chat during the presentation. So please stay tuned and let's participate and make this session great. So we would like to start with Dr. Alan McKay. Dr. Alan, thank you very much for being here with us today. The floor is yours.
Thanks very much. And first of all, I'd like to say it's great in my role as president of the Center for Neurotechnology and Law. It's great to partner with the AI collective in this event. So that's wonderful. And so I'll get started. So many may have seen or the film Minority Report, or perhaps read the novella, but it involves a kind of pre-crime form of predictive policing, and the way it seems to be done in the film and in the book is that there are some sort of mutants that are suspended in water, and they've got some kind of prescient power where they somehow know the future. It's not explained how, and they're hooked up to some sort of neural device, and their images of the future are decoded from their brains, and then they're relayed through the pre-crime system to police, and police act on this information and arrest people before they commit crimes, and then they're punished before they have committed a crime. The first thing to note about it is in connection with free will. Somehow these precogs, as they're called, they know the future. It's not entirely clear how. It doesn't seem to be a scientific reason that's given for their knowledge, and that seems a little bit analogous to a debate that exists in the free will debate for those of a theological persuasion, where there's the issue of what's known as God's omniscience, or divine omniscience, or God's foreknowledge. And the idea is, if God knows everything about the future, including everything that anybody might do, how can they be free? How can they have free will? And I guess a similar kind of thinking might go towards the precogs. If that's the case, the precogs know the future, how do people have free will? So you might think, well, okay, they actually just don't have free will in the Minority Report world. If that's the view, then you might think, well, in that case, the aims of punishment should change. Because they have no free will, they don't deserve punishment. And so really, in the world of Minority Report, they should move to a kind of a sort of benign incapacitation where people are kept in a hotel, rather like quarantine or something like that. Or or move towards rehabilitation or something, but they shouldn't give them hard treatment like the criminal justice system currently does amongst its other aims. So I guess the Minority Report raises issues relating to the aims of punishment. Another issue in Minority Report is the presumption of innocence. And so the idea is that it's on the prosecution to prove that somebody has committed an offense, and punishment is for what the prosecution have proved beyond reasonable doubt, rather than what you might do in the future. And the world of Minority Report, where people are arrested and convicted and punished even before they've committed crimes, seems to violate the presumption of innocence. Now, one thing to note in the film is that the precogs, that's the predictors, they're not always unanimous. And, so it might be the case that, that there is no free will, and they're not unanimous just because one of them gets it wrong sometimes. But actually there's no free will. Or another possibility is the reason why there's fallibility in the precogs is that there is some kind of robust form of free will, a libertarian form of free will, as it might be called, and that makes prediction impossible. So you might think, well, maybe they should have a presumption of innocence, especially since the precogs are not always unanimous. But this brings to mind, more sort of contemporary developments in technology. So you might have heard of the COMPASS system, which is basically it's a kind of statistical algorithm. I think it's too much to say it's AI. It's just a statistical algorithm that that has been used in some criminal justice systems, including in the US, to try and engage in what's known as predictive policing. And it's even been used in the context of bail, parole, or even sentencing decisions in order to make a determination whether somebody should get bail or not. The machine makes some risk assessment. And that's been controversial. There's been controversy about racial bias in the way the device operates. There's concerns about it being a black box and unable to explain its decisions. At least an expert witness might be able to give some explanation. And then there's concerns about actuarial justice. Now, to move forward to more sort of full-blooded AI, then interestingly today, I don't know if you saw, but I woke up this morning and I look at the New York Times, and there's an article there about a Chinese company called Gauge Networks, and they use an AI product to predict who might become a political dissident. And so you can see how concerns in the criminal justice system also seem to relate to concerns about a functioning democracy, or the state individual balance of power, and concerns about authoritarianism. But anyhow, these are kind of background to the main story for my talk today. So one thing to note is the precogs. They are hooked up through some sort of neurotechnology, which enables some of their thought processes to be decoded. So there's kind of a neurotech dimension to Minority Report, which is not usually its main focus. And you might think of the precogs, these are beings of some sort, and you might think that there's an infringement of their right to privacy in having their thoughts decoded in this way, and an infringement of a right to mental privacy. And there seems something concerning if they are indeed some form of human being, that there seems to be a human rights issue in treating them, using them as a means to an end in the criminal justice system, and decoding their thoughts in that way. All right, so I'm going to now talk, instead of statistical algorithms and also AI predictions, I'm going to sort of focus a bit more now on neurotechnology and the use of neurotechnology in criminal justice. Now, if you think about neurotechnology, so these are, I'd say neurotechnologies are technologies that monitor the brain or peripheral nervous system, or stimulate it, or do both. And if you think about something like a hospital brain scanner, that might be a sort of, it's not the exciting new form of neurotechnology that everyone's talking about now, but it is a kind of neurotechnology. And brain scans have been used in criminal justice for a while. So they're sometimes used in sentencing. And maybe the defense might say the defendant is not very morally culpable for what they do because they've got a brain abnormality. And then a contrary argument is, well, this brain abnormality is a reason to think that they are dangerous, and make a sort of prediction that might be factored into a sentencing decision. So that side of things is not particularly new. The thing that is newer in criminal justice is the police use of neurotechnologies in some jurisdictions. I'm guessing that Purvi might talk a bit more about this later, so I won't talk about it at length. But there are some companies that make devices, sometimes EEG readers, for example. There's a company called Brainwave Science, an American company that has a product called iCognitive. And basically what it is a EEG headset. So it's a wearable device. And the idea is that if you think about my apartment, the inside of my apartment, I'm in the office now, not in my apartment. If you think about the inside of my apartment, I'm the only person who's seen it. So if you show me a picture of it, I recognize it. If you show anyone else a picture, anyone else here, they see it for the first time. So this EEG reader, in conjunction with an algorithm, is supposed to detect recognition through a P300 wave. And some police forces are now using that. I think for quite a while in India, but other places are using them. I'm going to talk about some work that Interpol and the UN Office on Drugs of Crime are doing, and I think that's probably what's prompted them to act. And the concern is, well, there's a couple of concerns, is there's not much peer-reviewed papers about the efficacy of the device. That's one concern. But even if the devices work, there's further concerns about human rights. So one obvious right is the right to privacy, of which mental privacy seems to be part of. And then the other one is a right that nobody really cared about, but it's in the Universal Declaration and it's in the International Covenant of Civil and Political Rights. Nobody cared about it for 70 years, but it's the right to freedom of thought. And the UN Special Rapporteur has said there's a privacy dimension to that. And so there's some human rights concerns. Now, moving on from that, just keeping with the neurotechnology and criminal justice. Now, there's quite a lot of excitement about neurotech. Famously, Elon Musk has got Neuralink, and then more recently, Sam Altman personally and OpenAI as a company have invested in a brain-computer interface company called Merge Labs. Meta's got acquired Control Labs some time ago, and they've got a wearable neural device. And then amongst venture capitalists, there's a lot of venture capital money now going into neurotech. And then just in my university, for example, like biomedical engineer, academics, and might have a little neurotech startup. So what I take from that is I take that there's going to be more neural devices around next year than there is this year, and more the year after. It seems to be an industry that's on the up. And so I think what we can assume is that people will start to commit offences if they haven't already. They may have already using neural devices. Now, for people who know criminal law, there's kind of at least in serious crimes, the prosecution have got to prove the mens rea, the guilty mind, and also the actus reus, which is usually an act, the criminal act. You know, so like to murder someone, if you intend to kill someone and perform an act causing their death at that time, unless you've got a defense, you're a murderer. And the intention to kill is the guilty mind, and the act causing death is the actus reus. Now, of course, when people act, they usually act through their bodies. You know, so they use their mouths to utter untruths. They use their muscle systems to depress triggers on guns, throw punches, stab. And there's something odd about new possibilities. So now, if you take, for example, Neuralink, the Nolan Darbuck, who's the first recipient of a neural implant, he plays games online and can turn off the lights and, you know, interact in a way that is wonderful, and it provides autonomy, and it's to be celebrated. But of course, the flip side is, you know, like if you can interact with the internet, you can commit a crime. And, you know, so one question is, like, the prosecution might have to prove a mental state, you know, like intention, that's the guilty mind, and that might be proved in the normal way. But there's something odd about somebody who, say, just makes an act of the imagination, causes a neural device to move a cursor, and that triggers something in the virtual world. It's a non-standard act because the muscle system isn't used, and the distinction between the guilty mind and the criminal act doesn't seem quite so bright. It kind of seems like it's all in the mind in a sense. And so one possible problem or strange thing, I don't think the courts will say somebody's not guilty just because of brain-computer interface, but it causes us to rethink what the criminal act is. Is it a mental act? So is the thing the prosecution that you did, that the prosecution have to prove beyond reasonable doubt, is that a mental act? Or do they think of it this way? Well, if you imagine waving your hand and that was the command to move the cursor, and is that jiggling your motor cortex? That just sounds weird, but that keeps it sort of bodily. So anyhow, it involves a bit of a rethink. I don't think it's a big problem, but it's just an odd thing for criminal law. Then if you think about neural devices, like neural devices, you know, we're all talking about cybersecurity now. Clearly, cybersecurity capacities have increased since Mythos, and that seems likely to continue. And neural devices will be hacked, and they have to think about cybersecurity. Now, if you think about hacking into a bank, that's one thing, but hacking into someone's brain seems worse, or it seems different at least, and so there might need to be new forms of criminalization, new offenses. Now, another thing to think about is, you know, like I mentioned, if somebody kills someone at a time where they intend to kill them, then unless they've got a defense, they're a murderer. What might be a defense? A defense might be the insanity defense. So one thing I've written about is, let's say a person has got a neural device. Maybe the neural device is implanted and it aims at treating a therapeutic condition. They've got some kind of condition. The neural device manages it, as some people have. Like I met a guy recently who has got deep brain stimulation. I mean, just on a trial for depression. Some people have got neural devices. But let's say a person with a neural device, the device either gets hacked or it just fails and it triggers a hallucination. And at a time when they are hallucinating, the person kills another person thinking that they're an animal. So the test is, the insanity defense is, if you don't know the nature or quality of what you did, or you don't know it's wrong according to the ordinary standards, the standards of ordinary people, as a result of a disease of the mind, and that has caused a defect of reason, then you've got the insanity defense. So in this case, it seems like the person doesn't know the nature and quality of what they do. They're killing an animal when they think they're killing an animal. Actually, they're killing a human. So they don't know the nature or quality of what they did. They're hallucinating. That's a defect of reason. Tick. Is it a disease of the mind? Oh, that's where it's a bit weird, because it's kind of like, is the neural device part of the defendant, or is it a tool? Where does the defendant end and the tools they use begin? You can even imagine, like in the future, maybe some of the processing is done in the cloud or something. So there's a kind of a question: is that a disease of the mind? Or is a defendant to be seen as a cyborg and think of it that way, or you think of it as a defendant with a kind of tool that is somehow they're using? And then moving on now to sentencing. So if you think about sentencing, I'll give the example of an epilepsy device to think about how a device might be employed in sentencing. So there's a company called Neuropace. The epilepsy device, what it does, it monitors the brain all the time of a person with epilepsy. When it detects the neural precursors to a fit, it predicts there's going to be one, so it's kind of predictive, and then it stimulates then to avoid the fit, to avert it. And it works well enough to be FDA approved in America. It's in some people's heads. It's not clinical trial. It's gone beyond that. Now, you can imagine the same device for an angry outburst. So if somebody's anger starts to mount, there'll be some neural signatures that go along with that. And you can imagine a device that just stimulates to calm them down and sort of pacify them. I can imagine and have written about that being used, possibly be used in a sentencing disposition. It's in a piece called A Clockwork Orange again. You might remember that film. And but that seems to raise issues about, one is the device monitors the brain all the time. So there's a privacy dimension. Where's the data go? Is it up in the cloud? Can it be hacked? Can it be repurposed for something else by the company that's running it? And the other is the stimulation part, which seems to relate to autonomy. It seems to be kind of a removal of some kind of free will, which you might think is okay, or you might think, well, that's gone too far. State shouldn't be in that business. So anyhow, like to summarize, there's legal doctrine issues. What's the criminal act? What's the boundary of a cyborg defendant? Where does the defendant end? Then there's issues about manipulation and privacy. And now some people have said, well, okay, so what's to be done? Some people said there should be new rights. Like back in 1948, when they signed when the Universal Declaration was proclaimed, they weren't thinking about these kind of issues. They were thinking about gas chambers and those kind of horrors of World War II. So maybe we need a new right. And some people said that we need a new right to cognitive liberty. That's one proposal. Another proposal is, and the one I favor, is develop existing rights. So there's the right to privacy, the right to mental integrity, the right to freedom of thought. They're already in the human rights system. That's my favorite approach. So what's actually being done? So later tonight, I'm on the expert reference group for the UNESCO readiness assessment methodology, looking at countries trying to make a tool that enables countries to look about how ready they are in respect of the challenges from neurotechnology and the benefits. Interpol, I'm also on the expert reference group for the Interpol UN Office on Drugs and Crime. They report on neurotech. That's coming out later in the year. In my country, the Australian Human Rights Commission, they've proposed a moratorium on the use of neurotech. They just said, just don't do it until the Australian Law Reform Commission can consider it. That doesn't have the power of law, it's just a recommendation. So to conclude, like I started off with free will. I've written about free will. The free will problem hasn't been solved and I've given up on it. And really what I'm doing now is just sort of focusing on how to respond to neurotech. We're still working out how to think about these new neurotech possibilities. And I just want to end on with another film. So Minority Report, we started with, I think another film or another piece of art that's worth considering right now is The Ghost in the Shell. So the anime manga Japanese franchise as it is now. And in the Ghost in the Shell world, there are robots, there's AI, there's people with brain implants, including the main character is in neurotech, and there's quite a big focus on the network and hacking. And it seems like that's kind of the future of criminal justice, where there's AI, robotics, neurotech, networks, and that series prompts us to think about those things. So I'll stop there. If you want to look at my publications, they're on my Google site. And thanks very much. I'll finish up there.
Thank you. Thank you so much, Dr. Allen. I'm gonna post your books here for the audience afterwards. Well, I think you finished your presentation and we should move with Dr. Purvey, but I would like to just warm up the debate a bit. And I have one question for you regarding the efficacy of those tools. Generally, in the market, we see a lot of publicity and marketing around neurotech as something that is enhancing human cognition, something that is positive because people can achieve higher levels of focus, consciousness, and many other things. But the companies that are producing those devices are not revealing much about how they do work in practice and how, for instance, one brain signal is translated into an emotion or as an indicator of something that is going on inside of the mind of that person. And as far as I have researched to this point, this translation from the biological signal to what it means behaviorally or psychologically speaking can be very blurred and confusing. Even some scientific theories are questioning this translation process, let's say, by saying that it's not exactly precise. What do you think about that? Like, as a democratic society that is ruled by the rule of law, should we trust those devices that much, scientifically speaking, so that we can use them even for crime risk prediction when they are not exactly predictable and precise?
So I think that, so for quite a long time, I've been working on the implications of neuroscience for criminal justice. And there was a debate about brain scans, and really a question was what can be inferred from brain scans that's of legal significance. And it was never entirely clear to me that there was a great deal that could be inferred that was really of great legal significance. And maybe the best way of trying to delve into someone's mind is see how they behave and things they've said and all that sort of thing. Then, when it comes to the devices that, purport to detect things like guilty knowledge if somebody has seen a crime scene, then I don't think there's much peer-reviewed stuff to say that it works. It might do, don't know. But I think irrespective of that, it's going to come in criminal justice because, like, some police forces use it, and some defendants put forward, accounts of mental incapacity that rely to some extent on a brain scan. So, like, the law can't really dodge it. They have to consider it in some way. But I think the more important thing is that there's increasingly going to be more and more people with neural devices, and there's going to be real-time data at the time of offending from the neural device. And then a question becomes, should the police have access to that, or is that some kind of thing that should be shielded for reasons of mental privacy and freedom of thought? So yeah, right now I'm not sure that there's much to be inferred from the tools that are used in criminal justice. But I don't know, maybe Purvis might have a different view, and I'll be interested to hear her view.
Sure. Thank you for this answer. So let's continue with Professor Purvi. Professor Purvi, the floor is yours. If you want to share your slides, you can share them here on the button. And please be our guest, and we would like to hear you now. Thank you. Okay.
Is it visible?
Yes, perfect.
Okay. So thank you very much for having me over here. And it's a great honor to listen to Professor Ellen McKay, who has been the pioneer in the entire debate of the neuro rights in neuroscience. So thank you so much. Today, my topic that I am trying to articulate is all about the forensic neuroscience and emerging jurisprudence of predictive criminal governance. As we all know, for the centuries, the entire criminal justice system have operated relatively on a very simple assumption. And that is very simple, that we investigate crimes after they occur, we determine the responsibility through the due process, and impose punishment after guilt has been established. That has been a very standard practice that we have been following. But as we all know, that this emerging technology, that these technology are challenging this sequence. And as we all know, this artificial intelligence now predicts the behavior, algorithm generate risk scores, and neuroscientific tools claim to reveal patterns which are associated with this impulsivity, aggression, recidivism, and brain-computer interface. We have seen so many technology. Professor McKay has already discussed about that. These BIC, and the neural monitoring technology, they are moving from science fiction into a practical reality, as we have seen and we have been observing in some of the jurisdiction. And that's the reason that the question that I intend to explore today, being the scholar or being the student of the criminal law as well as the constitutional law, the question that I intend to explore today is therefore whether prediction is possible in terms of, and whether if at all this kind of a prediction is possible, whether they will be able to pass through the test of the constitutional due process, meaning thereby the constitutional democracy can embrace the predictive governance. Should we embrace this predictive governance model without abandoning the founding principle? I'm sorry, I have little throat issues. The foundational principles upon the entire criminal justice system is rested. And the core question is, can criminal justice punish probability? That's the fundamental question that we intend to ask. Or rather, I would say that whether the responsibility must remain indispensable foundation of legal accountability. In what way we are moving? That's a question I try to discover from my talk. Now, as we all know, let me move to the next slide. Is it visible?
It's still in the first slide,
First
but it's
slide.
visible.
Okay.
So you can just move and I think it will go.
Yeah, yeah. Okay. Oh, it's not moving. I'm so sorry.
Perhaps if you click on the second page there on your left.
Mm, just a minute. Okay. This is what happens when we use the technology. Yeah. Is this?
Yes.
I'm
I
sorry.
think you can close it and try to share it again, then the bug will probably be fixed.
Okay, let me try again. Yeah. Is it visible now?
And now it's on the second page. Thank
Yeah.
you.
So, the outline of my presentation today is forensic neuroscience as an emerging discipline. How do we look at it? The neuroscience foundations and the rise of predictive tools in criminal justice, law and ethics. What are the promise of the enhanced accuracy and prevention? What the question that Anna has asked, that to what extent we can rely on this predictive technology in integrating the principles of law and ethics, and what are the perils of premature applications and biases, as we have seen in some of the cases in different jurisdiction. So this is the outline of my presentation. Now, as we all know, as I said, historically the criminal justice evolved three major phases. The classical model that focus on individual responsibility and punishment for the completed acts, and that is how we look at the traditional criminal justice: the act, investigation, trial, and punishment. Now, the predictive governance model, which talks about the risk management model that emerged during the last 20th century, I would late 20th century, that emphasis on the dangerousness, prevention, and actual assessment. And this is how the predictive governance model is emerging. And that's the reason that we are entering what we might call a era of the predictive criminal governance model, where algorithms and increasingly using the neurotechnology seek not merely explain the behavior but to anticipate it. And this is how and this is very important to discuss about the responsibility versus probability conundrum, because today in most of the countries, at least I talk about India, the prisons are overcrowded, the recidivism is very high. And in that context, we need to look at this debate of responsibility versus probability, whether we should go for the predictive governance model or not, because we have seen the mental health disorders are disproportionately represented in all the correctional populations. And when we talk about the law enforcement agencies, they are also increasingly seek tool that can identify risk before harm occurs. The other day, I mean, before 2 days, I was in Bulgaria, Sofia. We were having the All India International Forensic Science Conference, and I spoke on the neuromodulation, that how do we use the neuromodulation tool for the rehabilitation of the offender. So probably the correctional institutions are also looking for some kind of leeway in this issue. And that is how the prediction appears quite attractive, because it promised the efficiency, prevention, and resource optimization, especially the countries like India, which is highly populated. The prisons are so much crowded. But as I said, every predictive system raises a very profound constitutional questions, and that we have to answer it succinctly. And that question is that at what point does prevention becomes the preemption? So this is the question that we need to ask. And in this regard, as I discussed, that classical classical theory, risk theory, algorithmic model, and now we move towards the neuro governance model. Now, as I said, why the rise of predictive justice and why it matters. This is what I discussed about, that the mental health burden and the resource constraint and the public safety expectations and all other, these are the concerns which some of the countries are facing enormously, and that is reason probably we need to move towards the prediction model. That's what I believe. Now, and this is the graph of the emergence of predictive justice model. It has started somewhere around in late 70s, the risk assessment used in psychiatry and parole in some of the jurisdiction. And then by 2010, we had a machine learning meta-analysis that shows the high predictive accuracy. And by 2020, we have been using the predictive policing and the AI governance model in some of the jurisdiction, and the debate has taken its own shape. So now when we talk about the forensic neuroscience, what is actually a forensic neuroscience? The forensic neuroscience, according to me, sits at the intersection of the brain science and the legal decision making. And basically, it examines how neurological evidence may influence question of responsibility, competency, sentencing, rehabilitation, and risk assessment. How brain can be used as an evidence, that's a core question. And the neuroscience has revealed so far some of the techniques that we have already discussed. And these techniques and the neuroscience has revealed remarkably very great insights regarding the biological foundation of the human behavior, and particularly significant are the functions of the prefrontal cortex that we have seen, specifically the functioning of the prefrontal cortex and amygdala. And these they're associated with the impulse control and the decision making and moral reasoning. And then how these parts of the brain is behaving, that is something which is very important for us to understand and assess while we are fixing the criminal responsibility. When we talk about the amygdala, they play a very important role in emotional processing and fear response and aggression. And that is how we have inadequate research which has demonstrated that there is a correlationship between the abnormalities in these regions and increasing behavior dysregulations. So this is something which the researchers have already established for the last couple of decades. But as we know, every science has a limits, and the neuroscience has also limits, because brain scans do not significantly and succinctly reveal the criminal intent. They do not establish guilt. They do not determine the moral blameworthiness, and they do not predict future criminal acts with the certainty. And that is the critical question, the critical questions and the distinction that we have to maintain, that whether the neuroscience may explain vulnerability or neuroscience proves or establishes guilt. So that is what we have to identify the fine distinction between these two, because neuroscience should not establish destiny for some individual. That is what I believe, unless and until we have a very robust data on this. So criminal behavior, as we know, that emerge from a complex interactions of the biological, psychological, and social factors, and no single neural marker can reliably, as of now, predict the criminality. As of now, we have the probability, but when we talks about the establishing the guilt, as of now, putting together all neural markers, we do not have a very I would say very robust system which very confidently proves that the guilt is there, or the guilt could be established. So the distinction is absolutely essential, that if neuroscience is to be integrated responsibility into the legal system or not, and if at all, how do we go about it? And this is how, because we have seen And then what neuroscience can tell us and cannot tell us. Neuroscience definitely can show the neural correlationship, cognitive impairment, executive dysfunction, behavioral vulnerability, all these things that can definitely use while we are processing the sentencing. But it cannot show the criminal intent, moral desert, or a future guilt or legal responsibility. So the correlations and the causation is something which we have to understand. So so when we talk about neurocriminology and risk factors, that goes beyond the biological determinism, and this is what we have already seen in some of the technology that is already prevailing today. We have existing technology of EEG, the functional MRI, brain fingerprinting system. Some of the system that our university has also innovated is the brain electoral oscillation signature profiling. So these are some of the system which is already in use. But when we talk about mm, proving the guilt and or the intention is something which is not yet being adequately being adequately been established. And when we move towards the predictive risk assessment models, we, as we all know, we have all these tools. We have Compass, we have HEART, we have CS, we have Prepol. So now these tools inform judges and administrators about some parameters and some abnormalities. But then when we talk about the algorithm, and the transparency and the algorithmic biases that some of the tools that may have, and specifically in Compass, which we have already talked about. So if we really want to use this some of the tools and would move towards the predictive governance model, then how it should follow. So as we know, we collect the data, then the algorithm is being framed, and we generate the risk scores, and then on the basis of the risk scores, we take the decisions. And specifically when we talk about decisions, is all about the interpreting of the scores within the context, and make the informed decisions, is something which is very, very important in terms of its expertise is required. And we have to look at, while we are taking the entire process into consideration, we have to look at the biases of the implicit biases and the explicit biases of the people who are involved in designing this algorithm. So bias, opacity, feedback, and automation bias, all these things that we have to look at it with reference to this entire predictive governance model. So because we have seen that presumption of innocence is something which, under the classical principles, we only punish when the act is completed and required proof beyond reasonable doubt. When we talk about the predictive detention, it restricts the liberty based on the anticipated risk, and basically we are using the statistical evidences, and at that juncture we have to ask the question that can someone be deemed dangerous before they actually act. And we have seen so many examples on this. So the brain data become an evidence, and when we talk about these data, we are largely depending upon the neural data, expert analysis, and then we are trying to correlate with the legal relevance. So these are the predictive technologies which we are already using in some of the jurisdiction: the EEG, fMRI, brain fingerprinting, the BCI, the brain computer interface. We also have brain image classifier, the BIC, the neural variables that we all are aware of. And then so these kind of a system which are already existing, which are emerging, and the future system which we are uh, already into the research is the real-time risk detection, continuous neural monitoring, which Professor McKay has already discussed about. So the question that arises before us, that how do we move towards from minority report to the neuro governance model? So basically, when we talk about the we have seen the issues of the Minority Report, that how the crime is being predicted before it happens, and what are the risks which are associated, what are the harm that is associated with this thing. So, so uh, should we go ahead with the algorithmic prediction, which ultimately lead to the neural prediction based upon the data, the brain signals and the data that we receive? And then should we go ahead with the preventive governance model, which has an intervention before the harmful conduct that occurs? So these are some of the issues that will criminal justice merely use the brain evidence or begin governing through the neural prediction? So are we looking at only the data, or we are looking at this new emerging technology which ultimately lead to the predictive, which gives us the predictive scores? So we have these cases that which we have already studied when we talk about some of the limitations of this model. So responsibility versus risk governance. So risk governance is basically looking at the future harms and prevention and incapacitation, and which looked at the actual scores, but then uh, whether the probabilistic reasoning is the accepted principles among the criminal justice system, or should be a guiding principle in times to come. So the real challenge is that whether the system should be just an advisory, or should whether this kind of a system should be the guiding principles of the criminal justice system. So we have already seen the predictive policing model, which are already in use in some of the jurisdiction. So global adoption of the predictive policing we have seen in the Netherlands, Germany, Austria, France, Estonia, and they use different kind of a system which are already available. Specifically, when we talk about the Netherlands, uh, the data source that they are using is crime, municipal and statistical data, and heat map, that is specifically for the burglaries that they have been using. In Germany, we have pre-cops. So these model are already available now. As we have seen, then when we talk about any technology, and which is basically based on the data driven technology, the more data that is getting generated, the clean data getting generated, and then the accuracy level as it increases eventually, as we all know. So when we talk about the international framework for the predictive governance, we have EU AI Act, we have GDPR, we have all OECD principles. And this is what Professor McKay was also talking about, that are we marching towards the entire new moment of accepting a cognitive liberty and freedom of thought, which is so sacrosanct as a part of our fundamental rights, which should be the part of our constitutional mandate and should be the part of the governing principles of the criminal justice administration or not? So these are some of the framework. When we talk about specifically of the Chile, as we all know, the neuro rights is being accepted as a part of the constitutional rights there, and this is where the entire framework is getting generated. Uh, so neuro rights and cognitive liberty, these are some of the emerging constitutional frontier. As I said, mental privacy, Professor McKay has also discussed about it, mental integrity, cognitive liberty, and psychological continuity. And why it matters? Because this matters because when if this is not being protected, then I think nothing is left for as a human dignity. And the future constitutional questions that we all have to ask for ourselves is that, can liberty survive if the thoughts become data? I mean, how do we protect the cognitive liberty? And it also becomes a human rights issue, because the protection of the mind from any kind of a hacking and encroachment of your mental integrity is something which is going to be a new emerging rights for different jurisdiction. Now, when we talk about the predictive governance models, what are the benefits and the potentials? Of course, it when we talk about benefits, it's all about the proactive allocations. We can deploy these resources efficiently, specifically for the high risk areas. We can go for the personalized rehabilitation, and this is something which is very, very significant, because when we talk about the rehabilitation model, there are hardly any jurisdiction which focuses on the personalized rehabilitation model. We have very generalized approach in most of the time. This is also tailor-made treatment for the individual risk profilers. If I talk about the research that we are carrying out as of now in Delhi, in our university, we have two major prison. One is in Tihar jail, which is the largest prison, and the other one is in Gujarat, which is the Sabarmati prison. What we are doing as of now, we have collected the data of the sexual offenders. We are first focusing on the offenders which have committed the sexual offenses, heinous sexual offenses. So, and they are already there as a convicted prisoners, and some of them which are who are already released after completion of the sentence. So we are collecting the data, we are doing the psychological profiling, and then we are classifying them in the low risk assessment, low risk individual, high risk individual, and the medium risk individual. And how do we give a differential treatment while they are in the prison, so that the recidivism issues can be addressed. So this is, as of now, we are undertaking this important project, and based upon this, the first hand, which we call as a preliminary data, probably we are going to replicate this to all the prisons of India. So and this is how probably we are also focusing on the individualized or the tailor-made treatment and the rehabilitation plan for those criminals. So an early intervention definitely helps, because it provides support for escalations as well. And what we call is a data-driven equity, because that reduces subjectivity and the human bias. No matter what, even in the absence of any kind of a neural data or any kind of a algorithmic assessment about the criminal, what how do we know that the decision, the judge who is taking a call or is pronouncing a judgment, may have all kind of implicit and explicit biases that we have already seen in most of the cases. And then how do we remove this kind of biases? So probably this data driven equity would help us to remove these biases as well. Of course, there are ethical risks and challenges, as I said. The first is a black box opacity. What we call is it lack, because at times this lack of explainability undermines trust and accountability. Like Anna has asked the question that most of this technology, the neurotechnology, is not explaining how it's actually functioning, and that really creates some kind of doubt. And they have their own reasons for to be so opaque. But then, unless and until everything is getting clear, that always raises the trust issues. Of course, the algorithmic biases that we all know, that is being discussed elaborately in number of debates when we talk about the neurotechnology. Many hand problems, because there are so many these particular issue is that diffuse the responsibility among the developers, vendors, police, because it is fixing the responsibility could be an issue. And the feedback loops nowadays, targeted policing generate data reinforcing model, and that feedback loop, if this particular issue is being addressed, probably the things would have been improved. And I'm very hopeful, because I am for the neurotechnology. If technology is coming forward for the greater good of the society, we should definitely go ahead it. But then when we talk about any emerging area, it takes its own time to mature. So probably we need to wait till the data gets more cleaner and the process is getting more refined. So when we talk about the fundamental rights, yes, when we talk about India, we do have a right to privacy, and we also have a Digital Data Protection Act. But when we talk about the mental privacy or the neuro right, that kind of a framework does not exist over here. And global norms, we all know Universal Declaration of Human Rights, UDHR, ICCPR, all these things that protect the privacy. But when we talk about the neuro rights specifically, these proposal seeks to enshrine into the mental privacy and cognitive liberty, and the kind of a document with which Professor McKay is now working with reference to the UNODC report, probably it will reinforce the entire issue of the mental integrity and neuro rights. So this is just a framework, legal framework, and we are making some kind of a comparison, specifically in EU, India, and USA. When we talk about EU, as we all know, they have a very specific norms for that. For India, we do not have a specific AI law, but yes, we do have some kind of a privacy data protection law, which takes care of the consent and purpose limitations, and penalties are also mentioned. And of course, in US also we have sectoral laws and some AI specific rules which is already being notified. But when we talk about the data protection, I couldn't find any federal law. However, we do have a sectoral rules and sectoral laws for that. So this is just for the understanding of the comparative aspects of neuro rights and data protection. That is I already discussed. I think that we should go. So now when we talk about towards the responsible predictive governance model, what we are looking at is the accountability, auditability, human oversight, explainability, proportionality, necessity, and legality. If these things are being taken care, I think we can definitely move towards the predictive governance model. We should definitely adopt this thing, because if it will help us to and specifically for the countries like India, it helps us to take care of the major issues of the criminal justice functioning model, because there's so much of pendency and the delays which already happening in most of the cases in India. So probably when we talk about this model through the continuous data collection, and we can probably create the possibility of the unprecedented predictive capacity, and that will really help us to develop this model further. So what are the red lines? Yes, the red lines is and how do we look at the future scenario? Yes, I would say the future criminal jurisprudence will depend on our ability to maintain the equilibrium between the science and liberty, prediction and dignity, security and autonomy, and biological explanation and moral accountability. So these are the few things which we have to think of it, because we have an opportunities, we have a risk, but then these are some of the questions that we have to keep in mind. And future directions, we need to have a cross-cultural validations to adapt any model. We need to always consider the dynamic risk factors, and they are to be incorporated in social media and any kind of a situational variables. Of course, the personalized intervention, tailor-made rehabilitation and support system could be one area wherein we can pitch in, and interdisciplinary collaborations like neuroscientists, data science, juries, which is happening eventually now, and the robust oversight framework. This is something which is very, very important. So establishing the independent regulatory bodies globally, that will really help us this area to further develop in a very responsible manner. Let us harness the science for justice without sacrificing the humanity. That is the final message for all of us, whosoever is interested in neuroscience and justice delivery system. So with this, I end over here. Thank you so much for giving me this opportunity. Thank you.
Thank you, Dr. Purvi. Thank you for this amazing presentation. You certainly left me with a lot of questions and doubts about the future of neurotech and criminal law, because this is a very instigating topic. And I'm going to open for questions now. So people in the audience who would like to ask a question, please type the question on the chat, or you can open the microphone. I will give you the opportunity now to do that in a minute. So if you would like to ask a question directly to our speakers, you can just click on ask a question, and then you can go on the queue. Okay, we already have someone there. So Francesco Stocchi is here with us. Hello, Francesco. How are you?
Hi, thank you very much.
Please go
I have a question for both Alan McKay, that I am really glad to see again. So, hello, Alan.
Hello. Hi.
And
Yeah.
Purvi Pokaria also. I think it was a very interesting presentation, and I would like to ask your point of view on something that is related to the future development of forensic neurotechnology. In particular, I have this idea that given the fast development of this technology, is it possible that in a future, in a close future, I would say, states will need to nationalize these technologies? So I'll try to reframe it. Given, like, in the one of the last slides that we just seen, there was this red line of trade secrecy that was against the rule of law. I think it's interesting because to me, if we allow only private companies and the private sector to develop this technology and to use this technology, then there can be some sort of issues on, I would say, wider security issues, or issues that are really affecting the rule of law, how we manage criminal law, and how we decides the objective for criminal law. So in this view, could it be something similar to the kind of discourse that I've recently seen on AI, where people are saying, for instance, with Claude Opus, that they were saying that if really Claude has become so powerful and so dangerous, wouldn't be possible that, I don't know, the US government or any other governments decide to nationalize it and say, okay, if you want to use it, we will control it. So that's like an open question that I would like to pose to both the speakers. Thank you very much.
I can go first since Purvi got cut off. So the question was about nationalizing. You know, should the state nationalize these technologies? Like, it seems a bit different from the AI question, because you know, like, one of the reasons why you know, an extremely powerful AI foundation model or something might be nationalized is because it's, you know, the risk of catastrophic risk, or the national security implications. So it's actually a risk to the state. Whereas in the neurotech space, the risks are there and they're serious, but they're kind of a different kind. So they're related to wrongful conviction and issues of mental privacy and issues of freedom of thought. Now, does that give reason? I mean, I suppose, you know, like one thing is, like, let's say the state gets into the business of mandating neural monitoring or neural intervention, and I mean, of course, that has got issues of the rights issues and the issue of the balance between the individual and the state. But let's say it does go that way. I guess, you know, if they don't if they don't have great control over the devices that are employed themselves, then they expose the people who are in the criminal justice system to other risks like manipulation or repurposing of data and stuff like that. And, you know, like maybe it could be possible to have just a situation where a court or a police force can't use any neuro device unless its state is produced by the state. I mean, but then the state's got to have the capacity to produce it. So, yeah, I mean, I guess, I mean, if you think about nationalizing all neurotech, I mean, that's a big thing, isn't it? Because much neurotech is therapeutic, and then the question is, you know, whether that kind of system would provide the medical advances that, you know, some people urgently need, people with locked-in syndrome and that kind of thing. But maybe some kind of narrower situation where neurotechnologies that are employed to serve the aims of a criminal justice system have to be produced by the state. That might be possible, but the thing is, I mean, like the way I envisage it. So let's say somebody, let's say neuro devices come in sentencing. The way I could imagine it happening is what happens is some device that's approved by the medical regulator comes on the market for the purposes of managing a particular mental condition. And then maybe in between offending and sentencing, an offender goes to, say, a psychiatrist, and the psychiatrist maybe consults with a neurologist, and they say, well, this neural implant might address your mental condition, and then you can go back to your sentencing, and then with the device already in. So in a sense, they've already kind of managed it themselves. And then the court, basically somebody turns up in court and they say, I've got a brain implant. I'm not so likely to re-offend. I just did it myself, you know, with on the advice of my psychiatrist, and it's approved by the regulator. Just make it a condition of a bond. And then the judge will have to decide, well, do I do it or not? Well, it's not been made by the National Neurotech and Criminal Justice Authority, but it's in the person's head. This professor is saying that it will manage the risk of recidivism. It seems hard. Yeah, it seems difficult. I don't want to say it's impossible. Maybe some kinds of, you know, like the kind of devices that are some police forces. If those devices are thought to be acceptable to use, then maybe for those kind of devices, they could be, you know, under the authority of a state manufacturer, maybe.
Yeah. Would you like to comment on that, Dr. Pervin?
Yes. In fact, I really like the idea. But I believe that nationalizing this kind of, creating a body, not only from the government body, but I believe that creating an independent body wherein we have different manufacturers or different companies who are working in this area, the best of the people from those companies, some of the independent policy makers, some of the people from the government. There should be an independent body who would be evaluating the proof of concept of this technology, this kind of a technology, they evaluate with all kind of a dimensions, because there'll be people from the civil society, people from the government, people from the legal fraternity, and these scientists, the neuroscientists. So there could be a nationalized independent body who would be evaluating this technology, would then the entire concept and the technology, the pros and cons is being discussed, deliberated, give a feedback to them, and then finally, once that is being some kind of proof of concept which is being approved, then supporting those companies in terms of some kind of finances, some kind of the facilities by the government, and then should promote the manufacturing of these kind of devices. So I'm talking about only those neurotechnological devices which we preliminary wants to use in the criminal justice administration, not the medical use devices and the other things. So I think this is a very good idea. We can definitely create this kind of a body, and I really thank you for giving this idea. Definitely, I would like to propose this to the government of India for having this kind of system. Thank you.
Yeah, very interesting idea indeed. We have a second participant here, John Daly. Would you like to go ahead with your question, John?
Sure. Can you hear me okay?
Yes.
Okay, great. So the question, first of all, I want to tell Alan and Purvi, this is such a great conversation. And it leads to my question. Good. So from the nuclear, let's go back to new technology. And in the 1940s, 1950s, the nuclear bomb development, right? So the United States uses it to end the war in the Pacific. And suddenly the population is left to say, what do we do with this? What's the morality of this? It feels like here we have some notion of the morality. How do we engage the population so that these quiet little kind of conversations that are happening behind the scenes in Alan and Purvi, the things that you're doing, they are not forward. At least by the way, aloha, I'm in Hawaii. It is so beautiful here, but it's not top of mind. Like, people are afraid of their jobs as it relates to technology and AI, but there's bigger moral questions. And so I guess I'm going to try to phrase this. How can we shape a conversation before the technology, before we drop the bomb somewhere, and then have to ask ourselves, was that morally sound? How can we have a conversation and engage the population to say, here are the choices? And then just to finish this, Purvi, your perspective in India is different than Alan's perspective in Australia, which is very different than mine in the United States. And yet there's some common concepts that we could start to educate people on. Starting with, is it moral to predict behavior? Is it, and then penalize it? And then secondly, where do the victims play into this? So a new neural technology comes out that prevents me from being a sexual offender, and yet I have already violated I'm going to use an extreme, 5 young women whose lives will never be the same. What's the balance? And I think all I'm pointing out is that the moral challenge here is very similar to the nuclear, except it's personal here. Like those poor victims in Japan, it wasn't personal, but it was specific to Japan. Does that make sense? And I'll be quiet. And I once again, Anna, such a great conversation, and why I'm asking this is I tell my friends what I'm doing and they're thinking, what? This makes no sense. And I think, you guys, you better start thinking for your family, for your children, for your grandchildren. And so thank you to all 3 and all the participants. Thank you.
Thank you.
Do you want to go first?
Yes.
Please, Alan, please, you may go ahead. Yeah, thank you.
Okay. So, one of the ways, I've been involved in a number of reports on neurotech, so the Australian Human Rights Commission and the Interpol and UN Office on Drugs and Crime, various others. And one of the ways we try and sort of in these reports we've tried to engage people is we have a sort of call for submissions, and you know, I've actually you know, tried to draw attention to particular organizations to make submissions. And so you know, like one way is engaging other people in order that their thinking can inform the shape of prospective regulation. But I think the other thing you said was about engaging the public so that they know about these issues, which is also important. And actually, I think you know, like I've tried to do some media pieces and do some talks and that sort of thing. But actually, I think art is quite important. You know, so for example, you know, people know Black Mirror, Ghost in the Shell somewhat, and these, you know, some of the, I think it's like the job of engaging the public is a bit wider than people who are working on the topics.
Yeah, and I think the challenge, sorry to interrupt, but the challenge is we have to make it clear. It has to be a simple question and start to have the conversation. If it were possible to predict that somebody was going to commit a crime and stop a victim from being damaged, what do you think? I'm not talking about a national election, a conversation. Start to get people to understand we've never been here before. We have never been to a place where the tools were actually in place to, within a certain level of certainty, we could predict badness. How far do you want to go? Because it feels like, and I promise you, I'll be quiet. It's almost a theological question, because if in the past, and I think, Alan, you brought this up, if God is and I am a believer, I'm a Christian, but if God is the one who understands our thoughts, when does our free will start to interact with that? And Purvi, I am not from a different faith base, right? But it's fundamental. We've been challenged with this forever, but now the tools are in front of us to do something about it. And I think personally, a small, simple conversation, culturally sensitive, because each country, each culture is going to come at this slightly differently. We got to start explaining to people we've never been here before. Never. Partially because of the tools in place, and partially because we've never have digitized all this information. And so I'm so excited, by the way. I cannot tell you, this is such leading edge. It's not the best model that we're talking about here. It's tech and civ from 1990 and how it's adjusting how we see the world. And you guys need to keep chomping at the bit to get people on board to understand the implications. Anyway, once again, I'm so excited to just listen.
I'll just say something very, very quickly, and then, I mean, like I can say the way I've tried to do it. I've tried to write opinion pieces, write articles. I've even written a short story. But you know, if people have got ideas of the best way to communicate, I'd love to hear. Purvi, what do you think?
Thank you. It's a very, very interesting insights. Thank you so much for posing this kind of questions. Well, I do agree when we talk about the morality and the prediction of a behavior is a big issue, and what is the repercussions of this system, if at all we bring into system bring into the arena, and how it's going to be the scenario. It's something which we just only can think. It's very difficult to ascertain. However, I would like to compare it with the concept of designer babies, or the concept of or the concept of what we call when we talk about the diagnosis of the future diseases. How how you are going to, how your body is going to react in, looking to your genetical structures and the kind of your habit you are having, how, what are the, 20 years down the line, what kind of a disease you are going to. So, likewise, this is a behavior of a body that we are already predicting now. Or we are talking about the look and the features of our babies. We talk about the designer babies which we are going to have now in future. So likewise, I believe that the prediction of this prediction of a behavior is something, yeah, it's new. It has never happened. So for us, we question the morality. But then if it is for the greater good, if it is not going to be a social taboo, and if you're going to use it very scientifically, as you rightly pointed out, there is no succinct structures and the clean technology which is available, which we can say very succinctly that this is with all kind of an accuracy, I would say. But then when any technology that comes, I believe that it takes its own time, to evolve and to get matured. So this is the beginning. Eventually 10 years, 15 years down the line, the situation may be very different. And if this prediction is helping for the prevention of a crime, or treating the people much well in advance, like you talk about that particular example of the sexual abuse. But then if in order to prevent the same person does not commit the similar kind of a crime for the other young ladies, we need to have I think it does have a moral issue, but then I feel that if it is being addressed properly, I'm for it. We should go ahead with this kind of model, because any new technology, whenever it comes into system, we will have all kind of an apprehensions and all kind of a predicaments, and of course all kind of a suspicion. But then eventually, with the time, it gets matured. And all problems get settled, all questions get settled. That's what I believe. Thank you. I hope I'm being able to address your query properly. Thank you.
Yes, this question was very insightful. I would like to also thank John for bringing this very insightful comment to us. And it made me think of the ethical and moral aspects, of course, because we are digging into them now, but in a different direction, in the direction of the human importance and the uniqueness of human judgment when we talk about criminal law. So, in the benefit of time, this will be the last question, and this will come from me. In this case, I will finalize with the Q&A. I was remembering when we had the generative AI emerging in societies, especially when judges started using AI in order to draft their decisions. There was a huge debate, and I had followed this debate here in France and also in Brazil, because some of the people writing the doctrines of law and also philosophers, they were saying that people should have the right of a human decision, not an algorithmic one. And this is still a big debate because we know that the judiciary bodies in most of the jurisdictions nowadays are using AI in order to give judicial decisions. But some people, they say, look, this should be delegated only to human people, because we have in most of the constitutions nowadays the principle of the natural judge. And this is something that we have been replacing more and more with AI by saying that the quality of the judgment by a decision made with AI is higher. So because of this, because of the risk of human error, we should give those decisions to AI. When it comes to criminal justice, this becomes a very sensitive and very complicated topic because, as far as I understand law, and I'm a lawyer as well as a background, criminal justice is one of the most sensitive domains of law. And it's one of the most sensitive because it touches a lot on morality and democratic issues. And this is why there is a high level of human involvement in criminal justice. We trust that humans are the right ones to judge and solve these matters. So if you think about, for instance, the trial by a jury, when people from our society come, they are chosen in order to help the judge decide the case. It means for me, philosophically speaking, that there is a principle behind by which we trust the community when doing those very sensitive decisions. And when I think about bringing neurotechnologies in order to help us with that, it seems very problematic in a sense, because then we take the community and the human judgment out and we bring something that supposedly will give us certainty in this decision that we have to make about people. So, how do you feel about those concerns in criminal law? Should we really be using algorithms in order to decide people's freedom? Or if one day the technology evolves so much, let's say in 20 years, and it's 100% sure, this is a good reason for us to be using this. Like, is this a good enough reason? Or there is something more in which we should consider perhaps that having humans or human judgment involved in this process is very important still, and we should keep that.
Yes, Professor Maki, would like, yeah.
All right. Oh, I'm happy to go either way. So, I mean, yeah, there's something troubling about the idea of a non-human judge. I mean, like, what one thing is, a question is, has the device got all the information in a way that's not rights infringing? But let's assume the answer is yes, and then the question is, can it just decide? I mean, like, one of the things I've argued in one paper is, like, in sentencing, I think there's some values that are incommensurable. So, like, when judges sentence, they're supposed to think about dangerousness and risk, but they're also supposed to give an offender what they deserve. So they're supposed to think of moral culpability, and there isn't an obvious common metric. And so one thing I've suggested is that, you know, maybe the AI models will start to get good at, you know, addressing novel eventual decisions, but that might be a reason. But let's assume further that they do, and then the question is, should they do it? Yeah, I haven't thought about it. I have thought about it a bit, but I haven't thought about it in a clear enough way to give you a good answer. But I'd like to offer a third possibility. One is you can think about a human judge, standard human. Another is an AI system. But I think the other thing that neurotech brings in is the idea of a cyborg judge that's kind of partly neurotech, and then that seems to muddy the water, because there's still you know, like, let's say there's a cognitively enhanced judge that has a neural device that's maybe even connected up to the cloud or something like that, and they get some of their information that way. Is it still it's like a sort of cyborg judge? And so I think neurotech might further make that already difficult question worse. But anyway.
Can I? Yeah, I just I believe that yes, all the neurotechnological devices should guide the human judge. I am not much in a favor of the AI judge or robot judge. Judge should be a human being. There are certain things which is irreplaceable with the human characteristics. But then, you know, the devices should be there. The different kind of the output that we receive, different kind of results, the prediction results, whatever we receive from the different devices should guide the human judge, or rather they should consider this thing as a part of the decision making process. That is what I believe. I mean, a human judge, I still believe in the humanity that lies with the human being. So yeah, I am a pro technology person, but at the same point in time, the technology should guide and support and help and assist, but cannot be replaced by human, cannot be replaced by technology. That's what I believe.
Yeah, and with this beautiful quote that humans are irreplaceable, we are going to close this event today in the Humans and AI Week. So everything is perfectly aligned there. I would like to thank you very much, Dr. Allen and Dr. Purvi. You really provided very interesting and amazing insights for us today. Your presentations were absolutely great. So thank you very much for contributing to society through these talks, because this is exactly what we are trying to do here: spread the word and bring awareness on these very important topics for the future of humanity. Thank you very much. I wish everyone a very nice day, evening, or afternoon, and we see each other around again, I hope, next time in our next event. Please keep on tuned and follow us on LinkedIn for more events. Thank you. Bye-bye.
Thank you so
Thank
much.
you.
Thank you, Mr.
Thank you very
Mackey.
much.
Thank you, Anna.
Thank you.
Bye-bye.
Cheers.